Good afternoon. This is Judge Lopez. Today is March 31st. I'm going to call the 1 p.m. case. First day hearings in 26-904-28. Today is a virtual hearing. There's no one in the courtroom. I just asked if you are on the line and wish to make an appearance, please hit 5-star and I will unmute your line. I would also ask that you please make an appearance electronically. Just jump on the Southern District of Texas webpage. You'll find a link to my homepage and a place to make electronic appearances, and they'll find a link in this case. So I'm going to unmute a few lines here. 212 number.
Good afternoon, Your Honor. David Feldman from Clifford Chance on behalf of the proposed debtors. I'm joined here today by my colleague, Maddie Nicolini. I'll be making some introductory remarks, and Maddie will be handling the balance of the first day motions.
Okay, good. Good afternoon. Here's another 212 number.
Good afternoon, Your Honor. Christian Jensen, Sullivan and Cromwell, representing Banco Santander and Deva Capital Investments, the agent and lender under the debtor secured facility.
Good afternoon. A 202 number.
Good afternoon, Your Honor. Jason Ruff for the U.S. Trustee.
Good afternoon, Mr. Ruff. And a 917 number.
Good afternoon, Your Honor. My name is Jamie Donat. I am the independent director at the Ultinon Holding Companies.
Good afternoon. Does anyone else wish to make an appearance? Just give me one moment. Okay, who should I turn this over to?
I believe it would be me, Your Honor.
Okay.
Thank you so much, Your Honor. Again, David, for the record, David Feldman, Clifford Chance, on behalf of the proposed debtors. We're here today for the first day hearing for three entities, each of which is as we noted in the papers, a First Brands affiliate, but we believe this is a separate and distinct and should be a fairly streamlined and hopefully simple case. The three entities that have filed are called Liberty 1 B.V, Liberty 2 B.V, and Ultinon Motion Holding B.V. We have with us today, as noted in the appearances, Jamie Donat, who is the independent director of each of these three entities. When I finish my opening remarks, I will seek to offer Mr. Donat's declaration into evidence and as his direct testimony in support of the first day motions, and we'll offer him up for cross-examination to the extent anyone has any questions. I will note that as of this moment, and not surprising, I think once we get into the substance of what we're requesting here, we have been in detailed discussions, as would be typical, with the U.S. trustee, and appreciate the U.S. trustee's efforts in navigating through our first day motions. But we have received no third-party formal or informal objection to any of our first day motions. We're also joined on the line by Gary Polkowitz of Teneo, who is the proposed financial advisor to the debtors, as well as a representative of Kroll, which is the proposed claims agent for the debtors. I want to thank the court for accommodating us for this first day hearing, and again, thank the U.S. trustee for their help and cooperation for getting through the first day motions fairly quickly, on a fairly expedited basis. Just to give you a little background here, the three entities that have filed for bankruptcy today are holding companies of a business line of First Brands called Ultinon. Ultinon is a successor entity to a business that was called Lumileds. Lumileds was an aftermarket producer of headlamps for vehicles around the world, with manufacturing facilities in multiple jurisdictions around the world, and was at a big market share in this particular industry. It was a business so in addition to the 3 holding companies, there are 20 some odd operating subsidiaries that operate around the world. Those entities are not before Your Honor and will not be before Your Honor in this bankruptcy proceeding. Several of those entities have already commenced insolvency proceedings in their local jurisdictions, with likely more to come. I'll get back to that in a moment, just from a corporate governance standpoint. But all of those operating subsidiaries that you see on the chart, which is attached to Mr. Donat's first day affidavit, first day declaration, those are the operating subsidiaries that we're talking about. So the Ultinon business was acquired from Lumileds in 2024. The business was acquired for a purchase price of $238 million. At the time it was acquired, it had EBITDA of, notes here, 60-some-odd million in 2022, and I think 48 million in 2023. It was until fairly recently an operating business, as I said, with manufacturing and sales facilities around the world. As of today, virtually all of those operations have ceased, and Mr. Donat was appointed as independent director for these entities. The initial appointment was for the 2 Liberty entities in November of 2025, and then subsequently in early 2026, he was added as the sole independent director of the holdings entity. The Ultinon Motion Holdings entity is the direct 100% shareholder of all of those operating subsidiaries that I have mentioned. The debtors do not have any employees or operations. It's a fairly simple capital structure. There is, as Mr. Jensen noted, a secured lending facility, and I'll get into what that means, at the holding company. The principal amount of that facility was used as acquisition financing to acquire the Lumileds business in the first instance. The debt sits at the holding companies, but has been guaranteed by many of the operating subsidiaries. Some of those guarantees are secured, some are not secured. The assets, I think one point that's important to note, the assets currently of the holding companies at this point is really limited to the equity value in the subsidiaries, of which at this point it looks like it's unclear that there will be any equity value in any of the subsidiaries. I think that will depend on how each of those operating subsidiaries is wound down and whether there is and can be any equity value remaining. There is some cash on hand, which will be principally used to fund this case. And most notably, there are what we believe to be a series of litigation claims arising out of the notion that this was a fully operating business when acquired, and less than 2 years later, it is an insolvent business with insolvent operating companies, where we believe that significant portions of the value of this enterprise have ultimately been transferred out to other parts of First Brands and other places. So we believe that there are viable litigation claims here that the holding entities have for the benefit of the creditors of those entities, and would like to preserve the value of those claims for the benefit of those creditors. We have been in discussions. One thing that's important to note is, and the reason we don't have a cash collateral motion before Your Honor today, is that while the lenders do have security interest in certain assets, they do not have security interest in the cash on hand at the debtor. So there is no. We've been working with them and coordinating with them as to our cash spend, given the limited amount of cash that's available. But there is no. This is not their cash collateral, nor are we seeking. Therefore, we don't need to seek use of cash collateral. So we had been in discussions with the lenders about the best course of action here, and we've been discussing the notion of the creation of a litigation trust for the benefit of creditors to pursue these causes of action at some point in the future. I think it's important to note, and as you can see from our cash balance on hand, we do not intend or expect to litigate any of these claims before Your Honor during this bankruptcy proceeding. This proceeding will all be about, in the very near future, we intend to file a plan, disclosure statement, and a litigation trust document that we will be negotiating, with our major creditors that would preserve the value of all these claims for subsequent prosecution by the beneficiaries of that trust. Probably to spend a moment on a little bit on the lending facility and then some of our other creditors and the reason that we are in this proceeding, at this time. So Mr. Jensen, represents the agent and one of the lenders in the facility. As I said initially, this facility was put in place as acquisition financing, but during a time period when the debtors were looking to determine whether there were viable sales of the various lines of business, including the Ultinon business, as we understand it, and some of this, certainly preceded, Clifford Chance's involvement, but also some of it preceded Mr. Donat's involvement as well. But there was a process that was teed up through the First Brand Debtors Professionals to seek to sell the various businesses. And while the Ultinon business was cash-strapped, there was various accommodations and extensions of credit and forbearances entered into by the lenders. As part of that process, the DIP lenders, in the main case, funded through a First Brand affiliate a portion of funds that were made available to the Ultinon entities. Without getting into all the detail, I think it's set forth in our first day affidavit, and probably Mr. Jensen can speak more to the details better than I can. But the end result was that this First Brand affiliated entity, effectively, which reflects the advances of the DIP lenders, that the First Brand affiliated entity holds currently approximately 75% of the existing lending facility, and the DEVA Santander entity owns the remaining 25%. And again, Mr. Jensen, if I've said anything incorrect, you can clarify or correct. In addition to that facility, there are certain trade creditor and service providers at the holding company. Substantially all of those service providers and contract counterparties were for the benefit of our operating companies. In the past several weeks, as cash was dwindling and operations at our opcos was winding down, we started to receive significant demands on various contracts by various of our contract counterparties, service providers, in addition to, and one of perhaps the more significant claimants at the holdco is LumaLeds itself. They were, given how recent this transaction was, LumaLeds was still providing transition services to Ultinon. They were asserting significant amounts due, and as part of an ongoing discussion with them on very shortened notice, they took action in the Netherlands to freeze one of our significant bank accounts. And once we became aware of that, while we were in the process of preparing for this Chapter 11, we expedited our timeline to file, and we found ourselves in bankruptcy as of the end of last week. As I noted before, we have not yet, and the hope and expectation has been that perhaps we would have even more streamlined the case and would have filed the plan, disclosure statement, and litigation trust vehicle in advance, but unfortunately we weren't able to do that. We wanted to get this case in, get the advantage of the global automatic stay to prevent further actions like this from occurring all over the world, as against any of our assets or cash that's sitting at various accounts. But we intend in the coming weeks, as I said, to file a plan of organization, disclosure statement, and litigation trust agreement with the cooperation of the lender group. I think maybe I would pause there. I probably forgot something, but I think that you get the gist of what we have here. There's obviously more detail in the first day declaration, but I'm happy to answer any questions that Your Honor may have before I move for admission of the Don't Ask declaration into evidence.
I have no questions. Let me just see if anyone wishes to make any brief opening remark before we launch into the evidence.
I'm happy to speak briefly, Your Honor. Once again, this is Christian Jensen, Sullivan and Cromwell, counsel to Banco Santander and Debit Capital. Mr. Feldman's description is accurate. You may recall there was a motion before the court in the First Brands case last November to provide for the on-lending of some DIF proceeds to the Ultinon business, which included a purchase of a sub-participation in the existing debt that was held by Debit Capital, the end result of which there's a 75-25 split between the intercompany lender, KTRI, and Debit Capital for both the super senior incremental facility that was provided in late fall, as well as the original acquisition debt that was remaining. I'll just speak very briefly, Your Honor, at the outset before we get into the motions that my clients are supportive of the relief requested today and the broader goal of this Chapter 11 proceeding to provide a forum to preserve these litigation claims, which are likely the most significant asset remaining for these businesses and the source of any recovery for creditors.
Thank you. Anyone else?
Yeah, just briefly, Judge, and Jason Ruff for the U.S. trustee. As was alluded to earlier, we did get a chance to review all the motions that the debtors filed today, and we're able to work through our comments. So you probably won't be hearing much from me, and other than me to confirm that, from my perspective, I think we're all set as far, and don't have any opposition to any of the relief that's being sought today. So unless Your Honor has any questions, I'll just be remaining quiet probably for the rest of the hearing.
Okay. Thank you very much, Mr. Ruffin. Anyone else? Let me just check. Okay, let's get into the evidence.
Well, actually, Your Honor, one more point that I was sitting here waiting. I realized I forgot to mention, and this is just, I guess, an FYI. The one motion that we had discussed with Mr. Ruff, and I had mentioned to you that at this point, a handful of the operating subsidiaries have commenced insolvency proceedings around the world. In order to commence those insolvency proceedings, it requires the sign-off of the 100% shareholder, which is this Ultinon Motion Holding entity. We had initially prepared a motion which would have, I would have characterized essentially a comfort order that we have the authority in the ordinary course of business to enter into, to sign off on those filings on a go-forward basis. Mr. Ruff had an objection to that relief, didn't think it was necessary. He can speak for himself. I think we agree, frankly, that this is, ordinary course to be able to sign off as a 100% shareholder, ordinary course corporate governance action of the holding company. I mention it for two reasons. One, that that's still an issue that's ongoing. where while the decision to file, whether to file or not to file, are being made by the operating companies, their boards and, their advisors, they do require, as a technical matter, a sign-off from the shareholder, and we intend to continue to provide those sign-offs, but to the extent there's an issue at any point, we may well come back to Your Honor on an expedited basis to seek authority to the extent we think we need it. We don't think we need it, but I wanted just to flag that for you as a placeholder.
Understood. Thank you for the update.
Okay. So at this point, I'd like to move into evidence Mr. Donat's declaration in place of his direct testimony. The declaration goes through some of the background information as I just described, but also it provides the evidentiary support for each of the first day motions that my colleague Madeline Nicolini will take to the court through. And again, Mr. Donat is available for cross-examination if anyone has any questions on any part of the declaration.
Any objection to the admission of the Donat declaration for purposes of today's hearing? Okay, it's admitted. And
okay, Your Honor, I'm going to shift my seat, otherwise, cede the podium to my colleague Madeline Nicolini, because we're sitting in the conference room, and she'll take it from here. Thank you, Your Honor.
all righty, thank you. And let me steal some thunder. Counsel, why don't you make an appearance? I'm going to move your agenda around just a little bit. Go ahead and state your name for the record.
Good afternoon, Your Honor. Madeline Nicolini of Clifford Chance, post counsel for the debtors.
Okay, good afternoon. I wanted to just get comfortable with where we were and before I signed joint admin, that I kind of understood the relationship and everything. I get the declaration into evidence, so I'm comfortable with where we are. I'm going to sign while we're talking joint admin. I'm going to designate this as a complex Chapter 11 case, and I'm going to approve the ex parte application for Kroll. So I'm going to take care of 1, 2, and 3 on your agenda while we're talking here. I'm comfortable with where we are, and then I know kind of that they need to be separate. And so I'll let you pick whichever one you want after that one, but I'll take care of 1, 2, and 3 now.
Thank you, Your Honor. Appreciate it. I'm appreciating the fact that you have just entered joint administration motion. We do just want to clarify on the record that the debtors are not seeking to jointly administer these Chapter 11 cases with the larger first branch Chapter 11 cases, which are being jointly administered before this court as well.
Yep.
Given the significant interest in the first branch group cases and the number of parties involved, we just wanted to clear that point to avoid any confusion and confirm that these cases are proceeding separately.
Yep.
So we just wanted to take that on the record quickly, and thank you for entering those orders.
All right.
So the first now item on the agenda is agenda item number 4, which is the debtor's request for authority to file a consolidated creditor matrix motion and consolidated list of the debtor's 30 largest creditors, as well as to redact personal information of individuals identified in the debtor's filings, as well as to seek the approval of the form and manner of notice of notifying creditors of the commencement of these Chapter 11 cases. The authority to file consolidated creditor matrix and consolidated list of the 30 largest unsecured creditors as contemplated by the complex case procedures would alleviate the debtors of the administrative burden of compiling separate creditor lists for each of the debtors, limit the associated costs where the debtors have limited cash on hand, and reduce the possibility of duplicative services. Accordingly, the debtors request authority to file consolidated creditor matrix and consolidated list of the 30 largest creditors for all of the debtors here. The debtors have further requested permission to redact potentially personally identifiable information of individuals included in the debtors' filings. This relief is particularly important here where the debtors operate in the European Union and other countries where applicable law imposes significant constraints on the disclosure of information relating to identified individuals and potentially significant fines for violation of those authorities. Finally, the debtor seeks approval of the form and manner of the notice of commencement to be provided to creditors, which is attached as Exhibit A to the motion. Unless Your Honor has any questions, we respectfully request that the order filed at docket number 6-1 be entered.
No, motion granted.
Thank you. And so the next item on the agenda is item number 5, which is the debtor's request for entry of an order enforcing the automatic stay protections under the bankruptcy code, which is filed at docket number 7. The debtors are based in the Netherlands. Accordingly, many of their creditors and other parties' interests are located in the Netherlands and other jurisdictions outside of the United States. While the debtors do believe that many of their creditors and other parties' interests are subject to the automatic stay, many do not have U.S. operations, and we anticipate that not all parties in interest will be familiar with the global reach and the self-executing nature of the automatic stay. Through this motion, the proposed orders, the debtors are not seeking to bridge or enlarge or otherwise modify the rights of any parties with respect to the automatic stay. As is typical in cases involving foreign debtors and foreign creditors and counterparties, we are seeking entry of an order simply confirming and reinforcing the protections of the automatic stay, particularly here where the debtors' creditors have already taken actions against the debtors' property outside the United States. Absent an order of the bankruptcy court reinforcing the protections of the automatic stay, debtors are concerned that parties may attempt to take improper action against the debtors and or the property of their estate. Therefore, we're seeking entry of an order to ensure that all parties in interest are aware of these provisions of the U.S. Bankruptcy Code, and the debtors believe that the motions as drafted appropriately lay out these key provisions. We did share the motion and the proposed order with the United States trustee, who did not have any objections to the motion or the relief requested here. So accordingly, we would respectfully request the order filed at docket number 7-1 be entered.
Anyone wish to be heard in connection with this motion? Okay, the motion is granted. I think it makes perfect sense in a case like this to grant such relief requested and it's really just restating the code and the provisions there, so it makes perfect sense to me. I'll grant the motion.
Thank you, Your Honor. So the next item on the agenda is item number 6, which is the debtor's motion for entry of an order authorizing the debtors to pay pre-petition obligations to certain critical service providers, which is filed at docket number 8. By this motion, the debtors are seeking permission to pay certain pre-petition amounts owed by the debtors to critical service providers in an amount not to exceed $15,000. Debtors Liberty 1 and Liberty 2 engage in services of a Netherlands-based corporate and financial services provider that performs certain financial reporting services for those debtor entities, as well as a Netherlands-based tax law firm that provides corporate tax filing support. These providers are critical to ensuring that debtors remain in good standing and in compliance with applicable statutory, regulatory, and governance requirements under Dutch law. And absent the engagement of these professionals, there is a risk debtors could fall out of compliance with applicable legal and regulatory requirements. This could result in potential penalties for the debtors and claims against the estate, which would not be in the interest of debtor stakeholders, particularly where the pre-petition amount to be paid is very limited. And saying at the outset of this hearing, the debtors and their advisors are fairly new to the situations, and we're continuing to get our arms around the information. We've limited the relief that we've requested today to what we thought was absolutely necessary at the time of filing based on the information that we had and what was strictly needed for the debtors to get through the first 21 days or so of these cases. We're continuing to review our books and records as well as to engage in communications with our contract counterparties. Based on that, there is the possibility that we may identify additional providers outside of these two that are specifically identified in the motion. And we may seek court authority to make certain pre-petition payments on account of those critical providers. We expect that those amounts be similarly very limited, but we just want to flag that for the court as well. And so unless Your Honor has any questions, we respectfully request that the order filed at docket number 8.1, 8-1 be entered here.
Anyone wish to be heard in connection with this motion? Okay, the motion's granted.
Thank you, Your Honor. So the next item on the agenda is item number 7, which is the debtor's motion for an order extending the time to file schedules of assets and liabilities as statements of financial affairs, as well as waiving the requirement or only alternative extending the time to file Rule 2015 reports, which is filed at docket number 9. As described in the motion, since an independent director has been appointed late last year and early this year with respect to both entities, we've endeavored to understand the assets and liabilities at the debtors as well as the operations of the non-debtor subsidiaries. While the debtors are holding companies with no employees and no operations, the ability to access the information necessary to compile the statements of assets and liabilities and the statements of financial affairs has been somewhat complicated by the actions of prior management and the current status of sort of the Ultinon business, including limited people remaining within the operations that are familiar with legacy systems and historical transactions. While Teneo, who's their financial advisor, has worked constructively with remaining personnel at the businesses, as well as Alvarez and Marcel, who's a financial advisor in the larger First Branch Chapter 11 cases. Given the amount of work, in completing schedules and statements, as well as the competing demands on the debtor's limited number of people within the Ultinon business, the debtors may not be able to complete the schedules and statements properly and accurately within the required time frame. Accordingly, the debtors are requesting an extension of the deadline by which the debtors will file the schedules of assets, of liabilities, and statements of financial affairs through and including May 10th, 2026, which is 45 days to the petition date, without prejudice of the ability to request further extensions. The U.S. trustee has reviewed the motion prior to the filing and did not have any objections to the requested extension of the time to file the schedules and statements. Through the motion, the debtors are also seeking a waiver of the requirements of Bankruptcy Rule 2015.3. And while the U.S. trustee did not have an objection to the extension of the deadline to file the statements and schedules, he did have an objection to the requested waiver of the requirement to file the report set forth in Rule 2015.3. And with full respect to the position of the United States trustee, the debtors do submit that the posture here is somewhat unique and a waiver is justified under the circumstances. As we stated at the outset, the debtors are affiliates of the debtors in the larger First Branch group, but we are not seeking to have these cases jointly administered. And because the debtors are affiliates of the debtors in the larger First Branch group, as part of the periodic report regarding value, operations, and profitability of entities in which the debtors estate holds a substantial controlling interest, which was filed as docket number 1389 in the larger First Branch case, in order to comply with the requirements of Rule 2015.3, the debtors in the First Branch group, Chapter 11 cases, did include in that periodic report each of the debtors, as well as each of the 20 non-debtor operating companies that Ultinon Motion Holding is the parent company of. Thus, any 2015 report that is filed in these Chapter 11 cases would contain substantially identical information to the disclosures that were already made in the larger First Branch group's filing, would be of limited utility to parties in interest, and would result in unnecessary duplication of effort and expense. Further, the best source of information for the 2015 reports in these Chapter 11 cases would have been the First Branch group entities, given the further dissipation of personnel from the Ultinon business, the limited available records, and that many of the entities that would be included in these reports are already in insolvency proceedings or preparing to be in proceedings themselves. And so it's unlikely that the debtors here would be able to provide more accurate or comprehensive information beyond what has already been provided. And while the debtors submit that a waiver is justified under these unique circumstances, the debtors do understand the importance of notifying parties in interest of the disclosures that have been made in the larger First Branch group Chapter 11 cases. And thus, to provide that notice, the debtors would propose to publish on the website maintained by Kroll, our claims and noticing agent, a link to the periodic report that was filed in the larger larger First Branch Chapter 11 case, and as well as file a notice on the docket providing parties in interest with a link to that filing, as well as the information necessary to access it. Based on these circumstances, the debtors submit that granting the requested waiver, coupled with the notice through Kroll, appropriately balances the objectives of Rule 2015 with the practical realities of these cases and serves the interests of debtors' estates and their creditors. In the alternative, if Your Honor is not prepared to grant a waiver, we would request the same extension of the deadline to file through May 10th, 2026.
Okay. Does anyone wish to be heard in connection with this case, with this matter?
Yeah, Your Honor, just briefly, I actually thought we had resolved this. What the counsel just went over there as far as an alternative, I was actually perfectly fine with. I think given the facts and circumstances here, I think what was expressed to me is that it would be very difficult for this team to be able to perform the work necessary to independently verify what had already been done in the First Branch matters. And there's very limited resources in this state. So given the very specific facts and circumstances of these cases, I thought what counsel proposed was satisfactory and probably, provided the same amount of information. Otherwise, I think they would have been left with the choice of just listing it and then maybe footnoting it in their global notes anyways, that they're relying on someone else's, work. So I think what council's proposing to do as far as just making the information easily accessible to creditors and other parties in interest in this case actually makes sense.
Yeah, I thought that made a lot of sense too. And I do like putting it on the website, just linking it. So if someone wanted to see it, that just made a lot of sense to me. So, Mr. Ruff is probably right. This may be the only case in which I preside over during my tenure here, in which I'll grant a waiver on the first day. But this one just makes a lot of sense and understanding. It's just a really, really unique fact set. I think I'm going to grant the relief requested here in the motion. Just ask that you put kind of whatever reports are there in the First Brands case, just kind of link them up so that someone wanted to see them, they could see them here.
Thank you, Your Honor. We'll do that.
So one question for you, Ken, is the order that you'd be asking me to sign, do I need to sign something different, or can I just sign the proposed order? And I'm more than happy. I don't need to order you to put it on the website, but as long as it doesn't conflict with anything that we're doing now, I think I'm fine signing the order.
So the order provides for a waiver. It does not explicitly go into the sort of proposed noticing through Cole. We're happy to upload a revised form of order if the court would prefer, or otherwise, we can have the proposal.
It's on the record. I'll sign the order. We all know what I'm doing. We can just get it. As long as that link is there, then I'm considering it satisfied.
Okay, thank you, Your Honor. We'll work with Cole to get that up as soon as possible. And so the next and final item on the agenda is number 8, which is the debtor's motion for continued use of the debtor's cash management system, which is filed at docket number 10. Through this motion, the debtors are requesting authority to continue their existing cash management system in the ordinary course, including maintaining existing bank accounts, engaging the services of non-debtor affiliates in the ordinary course, paying certain pre-petition obligations, and an extension of time to comply with Section 345B of the Bankruptcy Code. Before the commencement of these cases, the debtors operated as part of a cash pooling system where monies were swept up to Ultinon Motion Holding and paid down to the non-debtor subsidiaries that make up the Ultinon business to fund the operating costs of those entities. But the debtors' understanding is that cash pooling system has largely been shut down as of the beginning of this year. Today, in the ordinary course of business, debtors utilize an integrated cash management system that enables the debtor to monitor the collection and disbursement of flows as appropriate and maintain control of the administration of their bank accounts. As set forth in the motion, the debtors maintain 22 bank accounts across 5 banks. The majority of the debtor's cash is held in the debtor's primary operating account, has been used to make vendor disbursements as well as advance funds to other operating entities. 15 of the debtor's accounts are currently located at non-authorized depositories. We discussed this with the United States trustee and understand that the Office of the United States trustee does not object to a 45-day extension for the debtors to come into compliance with the requirements of Section 345B of the Bankruptcy Code without prejudice to seek further extensions. Through this motion, the debtors are also seeking permission to, in their discretion, continue a relationship with a non-debtor affiliate called GOC Automated Malaysia, which provides certain back office and finance support to the debtors at a cost of about $5,000 per month. The debtors submit that maintaining such service and relationship is critical for the debtors' transition to the Chapter 11 cases and to preserving the estate's assets for the benefit of its creditors, as this back office service provides much of the finance support that goes into preparing sort of reporting and as well as facilitating the payments necessary for the debtors to continue their operations. The debtors are also seeking authority to establish a professional fee escrow account and related professional fee procedures. The debtors have designated one of their bank accounts at JPMorgan Chase as a segregated account to hold budgeted professional expenses in these Chapter 11 cases, as well as fees required to be paid to the clerk of the court and the United States trustee. Through this motion, the debtors are seeking authorization to fund that account on a weekly basis each Friday pursuant to the budget, which is attached as Exhibit D to the cash management motion, which is also included as Exhibit number 6 on a witness exhibit list. The budget in this case is very thin and cash is very limited. As disclosed in the cash management motion, the debtors only have about $3.4 million of cash on hand, and as of today, a portion of that sits in a blocked account. And the budget for these debtor professionals is therefore very modest. While the professional free escrow account is not intended to function as a cap on allowed professional fees or expenses, it is meant to provide professionals in these cases with a limited and reasonable protection under the circumstances. We've shared the cash management motion and proposed order with the United States trustee, plus the minor comments to the proposed order that we've implemented in the versions filed on the docket as 10-1 and 2. We further provided the Office of the United Trustee with some information requested with respect to the debtor's bank accounts. And so unless Your Honor has any questions, we respectfully submit that the court enter the interim cash management order filed as docket number 10.10-1.
Okay. Everything makes sense to me. I'm going to grant interim approval of the cash management motion. This is just to allow the debtor to ease into the Chapter 11 process. And I think what we need to, when do you want to come back for a final hearing?
So we think that the week of April 27th, subject to Your Honor's availability, would work for a second-day hearing.
Let's see. Where am I? April 27th. Oh. Let me ask, are you planning on filing anything else that week to kind of go in? Or the reason I'm asking is it's going to have to be a virtual only hearing. I'm going to be out of town. I can get you in. But we can just do it. Let's see. No. Do you think we could do, and obviously if there's no objection to any of this on a final basis, why don't we do this? If there's no objection, just file a CNO. But
Okay.
Why don't we do April 27th at 3 p.m. Central. And then we'll do the objection deadline. Why don't we just give folks as much time as possible? Give them April 22nd. And then if there's no objections, just file a CNO. We'll take care of it.
Okay. Thank you, Your Honor.
Hold on a second. Let me fill this in so I don't forget. But it's going to be a virtual only hearing. I'm going to put April 22nd at 4 p.m. Central. That's the objection deadline. Okay. That is going to be signed and it'll hit the docket today. Is there anything else we need to take care of today?
That's it from us. That's it from us, Your Honor. So unless you have any further questions for us, nothing further from us today. Thank you again for Your Honor and your chambers for accommodating us.
All right, folks. Thank you very much. Have a good afternoon. Thank you.
Thank you.